The outgoing Justice Department may have been the most inventive in American history. You name a law, they'll find a way to twist it into something new or even the opposite, away from legislative intent and right in line with political preferences. Like how Title IX, the law to provide for women's opportunity in education, actually means that men are women. As long as they say they're women, of course, or reinterpreting the 9/11 era law that gave those who joined the military a pause on student loan payments actually means that everybody can have their debt canceled at any point upon presidential whim, or trying to make you an insta-felon by reclassifying what your gun actually is. So what you legally owned yesterday makes you prison eligible today without any congressional change in the actual law. And the list goes on, but there was another example of what sure looks a lot like inventive Biden-era malicious prosecution that somehow escaped me. At least I didn't hear anything about it until this week. But the reinterpretation of medical patient privacy laws to protect hospitals and doctors against the action of a whistleblower. And actually, the federal prosecutors in this case were backed into that position by their own incompetence. It's not the case they started with. It's just the one they ended up with because they were so bad at their jobs. Because it sure looks like they were motivated by politics, not truth or justice or fidelity to the law. This story starts in 2022. Texas Attorney General Ken Paxton issued an opinion that child gender transitions, at least in the physical sense, as in hormone prescriptions or surgeries, are considered child abuse under Texas state law and thus are prosecutable if committed. In a corresponding move, Governor Greg Abbott ordered state agencies to investigate instances of child gender transitions as child abuse and warned of criminal penalties not just for those who perform them, but for people who fail to report known instances. In response, Texas Children's Hospital, the largest pediatric hospital not just in Texas but in the entire country, issued a statement to announce they would halt what they called gender-affirming procedures to comply with the governor's directive. They said the mission of the hospital is to provide care within the bounds of the law, so they will stop the practices. At the time, Dr. Haim was a resident in general surgery at the hospital. He wasn't making these prescriptions or performing these procedures himself, but he learned in the days and weeks after that announcement that actually these things were still happening. There was a surgery where doctors implanted puberty blockers into an 11-year-old girl who believed she was transgender. He heard stories of other cases from his colleagues, and he said he reached the conclusion that the hospital was just lying to the public, saying they weren't doing these things while actually doing them in secret. In fact, making them a priority. So Dr. Haim acquired proof that it was happening, surgery and clinic schedules showing the activity on the calendar, drug and hormone prescriptions, surgical interventions, and more in pursuit of gender transitioning kids. Dr. Haim redacted these schedules to remove any personal identifying information of these patients, and he gave the material to Chris Rufo, who published it in May 2023. That whistleblowing was legally impactful. It prompted the Texas state legislature to pass a bill explicitly to ban transgender procedures for minors and not just rely on AG or governor interpretation of existing law. Governor Abbott signed the new bill into law on June 2nd, just weeks after Dr. Haim released that material. Okay, so what's the Fed role here then? This doctor blew the whistle, and not only is the Texas government not mad, they're appreciative. It prompted them to strengthen the law further. So why are feds knocking at this doctor's door, which they did at the end of that month? Well, for a supposed violation of federal patient privacy law, HIPAA, or the Health Insurance Portability and Accountability Act, which protects the security of a patient's health information, the feds accused Dr. Haim of illegally accessing and illegally disclosing protected patient information. Except he didn't, and was very careful not to. In fact, there are really two scandals in this story. The public dishonesty that the hospital showed to maintain its child gender transition practices, and then the incredible blend of incompetence and malice that the feds showed in prosecuting the case. And the case is now formally over, actually. Dr. Haim had been facing a decade in prison for his supposed crime. The trial was set to begin imminently, but then Trump was inaugurated, Justice Department leadership changed, and the case was dropped and dismissed with prejudice, as in never to return again. Dr. Haim and his wife Andrea did an in-depth interview with Catherine Herridge this week to tell the story. It's well worth the listen, and it's linked in the description. When you look at how this case was prosecuted, or at least how prosecutors planned to before they were ousted, it is all but impossible to conclude it was anything but some combination of incompetence and malice, because any degree of honesty would have ended it months ago. To that point, the Justice Department actually brought 3 indictments against Dr. Haim, the first one in May last year, and then a revised one in October, and then another revised one in November. Why did it take them 3 indictments? Because each one had serious errors on both the facts and the law.
What explains 3 indictments?
First of all, it is ridiculous that there are 3 indictments. This is absolutely speaking to the fact that this prosecution, they were trying any way that they could to manufacture an indictment out of non-existent law. That's why it failed.
They were going to do anything possible to make me pay for what I did.
On the law, a major reason for indictment correction is because prosecutors cited law that doesn't even exist. Yes, we know they're citing HIPAA generally, but that's a very big law with many different provisions. The law is particular and technical, and so the specific citation needs to be too, but prosecutors were not.
It says that you violated Title 42 U.S. Code Chapter 7, Subchapter XL. I couldn't find Subchapter XL. I mean, does it exist?
It does not. It's a typo. This isn't a typo of there versus there or something like that. This is the operative language of their indictment, the name of the statute that they're charging with, and they got that wrong in multiple indictments.
But okay, chalk that one up to clerical error, even though clerical accuracy is very important in this profession that we're all paying for in this context, by the way, but fine. That doesn't change the substance of their case. What does change the substance of their case is the facts at issue. And in changing their indictment several times, prosecutors implicitly acknowledged, well, they got the facts wrong too. A core point of the case originally was that Dr. Haim improperly disclosed private patient information to Chris Rufo, the guy who then published it. The first indictment reads, Person 1, that's Rufo, published HIPAA-protected information provided by Dr. Haim. The charges say Dr. Haim wrongfully disclosed individually identifiable health information. But what protected or identifiable information was disclosed? Because the material Haim sent to Rufo and that Rufo then published had personal information redacted. It protected patient privacy, actually. So Haim's lawyers asked for clarification, and prosecutors could not.
These exclusive internal emails show Dr. Haim's legal team pushed the prosecutor for evidence patient names were disclosed. His lawyer wrote, I have not been able to find an instance where this actually happened. The prosecutor eventually sent Dr. Haim screenshots of the hospital surgery schedule where Dr. Haim removed patient names.
And so prosecutors removed that piece from their indictment. First, it said that Dr. Haim disclosed HIPAA-protected information, but actually that's not true. So then it said he disclosed just patient information generally. Okay, but HIPAA-protected is the key component to the charge. If the information is not HIPAA-protected, well then disclosing it is not a violation under this law. Even more preposterously, prosecutors themselves did disclose personal patient information. In their indictments, they refer to these patients by their initials. That's information that Dr. Haim never released. So these indictments are making these patients much more identifiable than Dr. Haim ever did. These indictments are revealing personal medical information.
To me, this is one of the most unbelievable parts of this case, is that they're charging him with accessing private patient information, but the government released more information about child patients than Aton ever did.
Will these prosecutors now prosecute themselves? No, of course not. But okay, so Dr. Haim didn't disclose personal information like we did, but he did improperly access that information. That was their other piece. He accessed information for which he was not authorized. The first indictment says he was only authorized to access records for patients under his care, and these patients were not. They say Haim's last rotation at the hospital was in December 2021, but he improperly accessed these records in 2023. But the problem is, that's not true either. And prosecutors didn't just make some mistake and accidentally believing that happened. They were told that was not true by the hospital's own lawyers before they ever brought these charges. In August 2023, almost a full year before they indicted Dr. Haim, the hospital's lawyers told federal prosecutors that Dr. Haim had approved and authorized access to the hospital's medical records, and the hospital's policies and procedures were followed. They said, yes, Dr. Haim was working with patients at the hospital during the relevant time period. So he didn't disclose personal information as accused. He didn't improperly access that information as accused. What is this case even about anymore? Well, that's where we get the trademark Biden DOJ reinterpretation of the law. In the original indictment, prosecutors said Dr. Haim had maliciously targeted patients, but because they couldn't prove that, because it didn't happen, prosecutors amended the language to say Dr. Haim maliciously targeted the hospital and other doctors. But even if true, that's not a HIPAA violation. HIPAA is a law to hold hospitals and doctors accountable. It's not to protect hospitals and doctors. If the hospital or the other doctors think that Dr. Haim did something malicious to them, reputationally or otherwise, they can sue him. But that's not a criminal matter for federal prosecution. And of course, there's always more with the feds. There is no bottom to the barrel, actually. There is always another scrape. This prosecution wasn't just malicious, as in operating contrary to the facts that prosecutors themselves had. It wasn't just incompetent, as in wrongly citing the legal basis for the case. It was also corrupt, as in the prosecutor had a conflict of interest. The assistant U.S. attorney on the case, the woman prosecuting it, Tina Ansari, she actually had close family members with substantial financial and political ties to Texas Children's Hospital. The family runs a coffee company. The company sells a lot of coffee to the hospital. And Ansari isn't just connected to the company by family. She was formerly an executive. And so the DOJ kicked her off the case in November after she did everything she accused Dr. Haim of doing. She improperly disclosed personal information in her indictments. She improperly accessed that information insofar as her investigation was premised on lies. She acted with malice insofar as she had several pieces of information early to show that there was no case here, and she brought the case anyway. And so she should be disqualified professionally. But here's the other kicker. She kind of was. She was suspended from the Texas State Bar for failure to pay dues, making her ineligible to represent the government in this case. But she did anyway. And lucky for her, it looks like she got out right before she had to answer that Doge email explaining 5 things she did last week, because it would have been lies, fraud, and whoopsies. And dang it, I can't think of 2 other things. But according to her LinkedIn profile, she has moved on to the local DA's office in Houston for work anyway. I'm actually shocked that she wasn't promoted, but I guess Merrick Garland just ran out of time. As far as the U.S. attorney for that district, well, he moved on too. Biden appointed Alamdar Hamdani, who was the U.S. attorney for the Southern District of Texas, overseeing this entire sham. He resigned the night before Inauguration Day. So, will there be any accountability? No, of course not. These are feds. Dr. Haim should just be thankful they didn't shoot his dog in the face, or worse still, his wife while she holds their newborn daughter. But hey, at least now there's some truth in the matter. And in a world full of lies, every little bit of that is still something to appreciate. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X. That is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Those live on Wednesday and Sunday nights. Looking forward to it. Goodbye. Hey, if you made it all the way to the end of the video, that means you probably found some value in the video. If you found some value in the video, please consider supporting my material. You can do that one time or recurring for as little as $1 a month. It not only helps me sustain, but it helps me pay the people who make my videos possible. Linked in the description for you, mattchristiansenmedia.com/support. Thanks for listening.